How do you prove tortious interference in business? Imagine you're running a business and suddenly a competitor spreads false rumors that cause your client to cancel a big deal. You might wonder, how can I prove someone intentionally caused this harm? That's what we're here to figure out. To prove tortious interference in business, you need to show certain key points. First, you must demonstrate that there was a valid business relationship or a strong expectation of forming one. This could be an existing contract or a reasonable chance of making a deal in the future. For example, if you had a signed lease or ongoing negotiations, that counts. Next, you need to prove that the person you're accusing knew about this relationship or the potential deal. If they had no idea, they couldn't have intentionally interfered. So, evidence like emails, meeting notes, or other communications showing their awareness is important. Then, you must show that the defendant intentionally acted to disrupt or prevent the relationship. This means their actions were deliberate and wrongful. For instance, making false claims, using economic pressure, or spreading rumors that harm your reputation all count as improper conduct. Simply competing is not enough. The interference must involve wrongful means. Causation is the next piece. You need to prove that the defendant's actions directly caused the disruption. If your client lost a contract because of false statements made by the defendant, that's a clear link. It's not enough to show the defendant acted badly. You must show their conduct caused the harm. Finally, you must demonstrate that you suffered real damages. This could be lost profits, missed opportunities, or damage to your reputation. For example, if you lost a big client and can show how much money you would have earned, that helps your case. Sometimes, expert testimony is used to quantify these damages. When dealing with a prospective relationship that was not yet formalized, courts want proof that there was a high chance of success. You need to show it was more likely than not that the deal would have gone through if not for the interference. In cases involving existing contracts, proving wrongful conduct is usually easier because contracts are protected by law. But with potential deals, you need to show the defendant used improper means or acted solely to harm you. Actions like making false claims, applying economic pressure, or initiating baseless lawsuits are considered improper conduct. If the defendant claims they were just competing fairly, you can argue that their actions crossed the line into wrongful interference. Gathering evidence is key. You'll want contracts, emails, or messages showing the defendant's knowledge and intent. Proof of improper conduct and documentation of damages are also necessary. Legal counsel can help you frame your case and present the evidence effectively in court. Proving tortious interference can be complex, but with the right facts and documentation, you can establish that someone intentionally and wrongfully disrupted your business.